Hey, welcome everybody to the webinar. I want to thank you for taking the time out of your day and attending our webinar. And I want to thank Michael Angier for hosting it. Michael, I'll turn it over to you, and you can do the introductions, and we'll go from there.
Okay, great. Welcome to the call, everyone. I'm really glad that SuccessNet was able to host this with my good friend Alan Cutts, who I've known for a number of years. I'm going to introduce both he and Chip in just a moment. But here at SuccessNet for the last 20 years, we've been helping great people and great companies grow and prosper. And normally, most of the time, we're talking about strategies for success, principles of success. But we also have to get down to tactics sometimes. And if you're operating a business today, it's no longer the wild west on the internet. And so we have to really take care of business in terms of doing the things that work, not only work, but also that are legal. And so I thought that this would be particularly appropriate to bring these two experts in on a call so that you could learn from them and educate yourself about the things that you need to be on top of. So first of all, Alan and I have been masterminding for years, and Alan has spent over 24 years helping businesses like yours find new customers and increase sales to current customers. And Alan, he's a marketing and sales fanatic, developing business strategies, systems, and funnels that drive measurable marketing results for small to mid-sized business clients. And after meeting Chip and reading his latest 7 tragic legal mistakes that can get your bank accounts frozen by the FTC, and understanding the risk that small to mid-sized businesses were taking by not hiring an experienced internet attorney, Alan decided it was time to do something about it and teamed up with Chip to create FTC Guardian, the #1 FTC compliance training company in the nation. And I followed what Alan has been doing for a number of years, and when he told me about this program, I was very excited about it, and I knew it was an idea whose time has come. So and then Chip brings the legal aspect to it. Chip's practice as an SaaS attorney. Now, SaaS stands for Software as a Service, all right? And he's primarily been involved in representation of software SaaS and IT companies regarding intellectual property, licensing, SaaS agreements, SaaS reseller agreements, SaaS law, marketing and distribution transaction, privacy, and website legal compliance. Chip has extensive experience as an SaaS attorney in drafting and negotiating of contracts and hosted software agreements for the corporate market. So he knows what he's talking about. Chip also practices as an attorney in the area of mergers and acquisitions involving software, SaaS, and IT companies, and he's authored 4 books in the field of software and internet law. Chip is of counsel to the Atlanta corporate law firm of Jones and Haley, PC. So with that introduction, I would like to introduce you to both Alan and Chip, who are going to give you some great information and talk about why these 2014 tactics are so important. So, gentlemen, take it away.
Thank you, Michael. Chip Cooper here. I'm wondering if you guys can see my screen.
I can.
Yeah.
Good. So that's the topic. Tragic legal war stories show how the FTC could freeze your bank accounts and what you can do about it to avoid this happening to you. Now, before we get really going here, I just want to raise this question, and that is, we're going to be talking about war stories, which are really legal tragedies, I guess would be the best way to describe them. And these are real people involved with these war stories. And I've thought about them. I've read the cases involved, and we're going to talk about those in a little while. But I've often thought about these people and wondered about them. Were they really risk takers? Were they reckless? Were they, certainly I don't think anybody intended to violate the law. In fact, one was a lawyer So the best I can come up with, and I think most people have agreed with me, is they just didn't know what they didn't know. And now that's a cliche, right? I mean, it just is. But there's always a kernel of truth in cliches, right? They didn't know what they didn't know. They thought they were doing things, I guess, ethically, but they got into trouble because they didn't know the rules of the road or the strategies and tactics they should be following to protect themselves as they marketed and built and grew their businesses. And of course, ignorance is no excuse, and that's the big problem. That's the conundrum that we're going to talk about here in this call. And again, we have a big question, and I'm going to raise this here point for point because it's so important, and that is, do you sell to or do you collect personal information from consumers who are located in the United States? Now, consumers also include persons who work at home. I think many of those people, including some people on this call, view themselves as small business people, but if they work at home, the FTC, Federal Trade Commission, views them as consumers. So if you answer yes to this question, then I can say with certainty that welcome to the jurisdiction of the Federal Trade Commission, because this is what they do. They have jurisdiction over over those who sell to consumers or people who work at home. And it really doesn't matter where you're located. You can be located outside of the United States. As long as you sell into the United States, you're going to be subject to the jurisdiction of the Federal Trade Commission. So what does it mean? Well, it means several things. It means, first of all, that your personal assets along with your business assets are at risk. And it also means that there is a certain, I come up with a metaphor here. This 800-pound gorilla is really in control not only of your business assets but your personal and family assets, because if you're like, I'm sure 95 to 98% of online business owners, you really don't know what you don't know, which is exactly what we talked about a minute ago. And as long as you don't know what you don't know, this is the guy that's in control. In fact, he's looking over your shoulder every time you adjust the heading on a sales page or make a promotional post on a social media platform. Well, you know, not really, of course. This is a metaphor, right? And in some cases, it's referred to as the white elephant in the room. But whether you, I prefer the gorilla metaphor, but whether it's a white elephant or an 800-pound gorilla, the idea is the same, and that is that this represents something that is foreboding, something you worry about, something that's always there. You wish it would go away. You don't want to have to deal with it, but you know at some point that you're going to have to do it, and it really causes you great concern. That's the basic idea. So what do you do to control this gorilla? How do you take control of your business and your personal assets? Because if you don't know what you don't know, this guy is in control. Well, here's the secret. Very simple. Successful marketing strategies always include built-in legal strategies. And there are two keys here. Very simple. It's sort of like the secret to doing well with real estate investing. Buy low and sell high, right? And this is pretty simple, but the tricky part is executing it, right? And we'll go into some detail later about how you can do it and how a very complex process has been made very simple for you. More on that later. But the two keys are always, not sometimes, but always, and then built in, meaning that you don't put off the integration of these strategies until sometime in the future when you've accomplished some level or some plateau in your business. You need to build them in as you build your business, because if you wait, you're probably going to have to rebuild a significant part of your business. And in terms of list building, that can mean losing part of your list. And I'll probably cover some of that in just a few minutes. So what is the key to it, or how can I actually demonstrate to you something that hopefully you'll remember about this secret? And Alan, do you think everybody will sort of work with me a little bit on this? Will you check the chat box and see if we get some yeses there? I want to feel like everybody's with us.
Yep, got it.
What do you?
Do it.
Do it?
Do it, man.
Do it. All right, we'll do it. So here's what I want you to do as you're sitting there probably at home. I want you to hold out your two hands, thumbs up, and the palms of your hands maybe 4, 5, 6 inches apart, right? So if you're sitting there and you're like that, then I want you to wiggle the fingers on your right hand, right? And those fingers represent the strategies and tactics for marketing and building your business. And obviously you're focused on those. That's what you do, right? But then wiggle the fingers on your left hand. What they represent are the legal strategies and tactics that you need to employ to be successful in avoiding the risk involved, right? And that's what you actually don't know, right? You don't know what you don't know, getting back to that cliche. So as long as your hands are remaining 5, 6, 7 inches apart, the gorilla is in control because you haven't integrated those strategies into your business. So now if you bring the palms of your hands together and interlace your fingers, that is where, figuratively, you want to be, because now you've integrated the strategies and tactics along with the rules of the road to protect yourself as you pursue your marketing strategies and tactics. So that's really sort of a physical way that you might remember what the secret is, and the result is, if you conduct your business that way, you'll be able to worry-proof your online business, and that's what we'll show you how to do. All right, before we really get cranking here, a little housekeeping. The presentation is for informational purposes only. It's not legal advice. No attorney-client relationship is created, and we're certainly not endorsed by the Federal Trade Commission. Now, Alan, are you prepared to offer? This slide has sort of been in our presentation, but how many people are interested in my 4th book, the latest book published late last year, 7 Tragic Legal Mistakes That Can Get Your Bank Accounts Frozen? There's a lot, if I say so myself, there's a lot of very good information in here about strategies and tactics that can protect your business. Do I see I see some yeses there, Alan?
Absolutely. Yep.
Okay, so here's the situation. If you stay on the call until the end, the very end of it, Alan will show you exactly how you can get a free copy of the book that I think will be some very valuable information for you as you go forward with your business. So stay on with us at the end, and Alan will show you how to get it.
And I believe this is your 4th book, right?
The 4th book, and the most recent, published late last year.
Right.
All right. Just a very quick summary. I've been around for 30 years plus practicing law, software, SaaS, a lot of internet law. As the internet became a commercial reality, along with Jones and Haley in Atlanta, and you've heard all of this in the intro, so I'm not going to dwell on it. But I did serve as an adjunct professor of software law at Wake Forest University School of Law for 20 years. So I've sort of made the rounds in the software practice. And also on the educational side of the profession as well. So what are we going to cover in this call? 3 basic points. And first is why the FTC is now going after the little guys and why you should be worried. Now, I would like to extend an apology to you. I don't think you are little guys, right? I mean, I think all of us probably are little guys relative to Fortune 1000 companies anyway, right? But the FTC views you as little guys, so I use that term. That's not my term. So the second thing is, and this is something you probably don't know anything about, and I guarantee you if you do not, which is typical, you're going to be a little bit surprised at this. You're going to be surprised at the enormous powers that the Federal Trade Commission has. Nothing like what your conception of ordinary civil litigation is, where defendants actually have rights. If you're a defendant in an FTC case, they can shut you down before you even get served with the complaint. And I'll explain step by step exactly what it's like to get sued by the FTC and how your bank accounts and personal assets can be frozen and lost forever. And this business of freezing bank accounts is really, it's sort of struck a nerve with online business owners because they're not quite sure how that can happen. But I'll explain to you in significant detail how that happens. In fact, I'll show you some actual language from a complaint, or excuse me, a court order that shows you exactly what happens. And then third, real life examples of people who didn't think they were at risk. Again, they didn't know what they didn't know, but who got nailed by the FTC, and why it could happen to you too and what to do about it. So those are the three main points. Let's get started with the first point about the FTC going after the little guys. And I think Michael mentioned in his introduction that there's no longer the Wild Wild West, and he's absolutely correct. The time that the Wild Wild West ended was in 2009, a very pivotal year. Prior to 2009, it was the Wild Wild West, not a lot of enforcement, almost anything went, but it'll never, ever be the same again. Then beginning in 2009, going forward, we enter into a period that I call the tsunami of new laws and regulations by the Federal Trade Commission. And in addition to new laws and regulations, there was very aggressive and stepped up enforcement of existing laws and regulations. So that began in 2009. And to the present day it continues, but I think there's a new trend, and I'm going to mention that in just a second. But before I do, this is very important because a lot of the so-called little guys believe that as long as you're on the back row back there where the arrow is pointing, that as long as you're back there and the FTC's attention is focused on the guy on the front row with a bullet on his head, excuse me, the target on his head, that you're okay. You can hide back there, but you cannot. And here's why. The guy on the front row with the target has drawn the attention of the Federal Trade Commission because there have been consumer complaints, and I'll explain more about that in just a minute. So the FTC's attention is on the guy, but then they discover there's a group of people doing essentially the same thing. So in many cases, they will bring lawsuits not only against that guy on the front row, but they will group together the others, including the guy there on the back row, and they will bring a lawsuit separately, but they do it as a group or a task force approach. They've done it with the weight loss segment. They've done it with work at home segments, and of course there are others. So you need to understand that even though you're back there on the back row, you can't hide, and you're just as vulnerable. Now, this is the best illustration that I've come up with yet that describes what is happening from 2014 to the present day, and that is the drill down by the FTC against the little guys continues. But I believe there is just the beginning of a new trend, and that is this. We're all familiar with what relationship marketing is, and you've probably seen that quote by Ben Grossman several times: new marketing is all about relationships, not the medium. There's nothing really new and earth-shattering about that. Now, what are the drivers of the new trend that I'll identify in just a second? You have this pressure from the FTC top-down, this drill-down situation where the drill down is now focusing on the so-called little guys, and as a result you have a general awareness now, more so than in the past, of FTC enforcement. And of course the whole environment of the online business segment is now maturing a little bit. Relationship marketing has become into a really important factor in marketing, and that's reflected in the predominance of social media, and a very not so recent, but it's taking a lot of momentum now, gaining momentum, the use of retargeting, remarketing, online behavioral ads by marketers, and the consumer's concern about retargeting. All of these factors are drivers of a new trend. So what is it? Well, it hasn't really quite taken hold yet, but I see the beginning of it, and that is that FTC compliance is now integrated into relationship marketing. And you might ask, how in the world can that be? Well, it's really simple, I guess. I mean, we tend to think of FTC compliance as a defensive measure or measures, right, to protect us from potential FTC claims. However, because relationship marketing is now becoming more significant and all the factors just mentioned, the fact that FTC compliance is now becoming an offensive strategy and tactic because consumers are much more aware. They can come to your website and spot fairly quickly, or many of them can, a privacy policy that is not up to date. And other indicia of legal compliance. They can see fairly quickly a website that's either up to date or not, and now that relationship marketing is important, they would tend to do business with the ones who are compliant and doing it right. And I think that's going to be a more developed and profound trend as we go forward. Okay, number 2, segment 2, what it's like to be sued. And this is going to, you might hold on to your chair here because there's going to be some really interesting stuff. The first thing is, how does the FTC actually begin to build a case against you? Well, we all know that we're online 24/7, so any FTC person at his or her desk in Washington or at any of the regional offices can observe what you're doing online, right? In fact, this happens all the time. They can see your privacy policy, which is a huge source of liability, and other things, your marketing messages, that sort of thing. So they can build a case against you simply by direct observation. But where they really get started is the complaint funnels that they have. I mean, we all are marketers and we deal in funnels, but the FTC uses the concept of funnels as well. And this is one of the primary ones, and that is they have an extremely comprehensive complaint form. This is just a clip of the top of the first page. There are a number of pages involved in it. They ask for a lot of information about you and what you're doing and how you do business and why the complaint has been filed, and they use that as a basis to build a complaint, build a case against you. They also have a Facebook page. Now, granted, this is not terribly significant, but if you look down in the lower right-hand corner, they do have sort of a blog where people give reviews, and it's mostly a blog, a chat kind of thing, but they look there, they check it out, they see if there are complaints, because their stock in trade, you know, your mission is to drive qualified traffic, right? Their mission is to look for qualified complaints. And so this is where one of the sources where they get those. Now, these are the sources, and these are analogous to the affiliate networks that many online businesses use. These are the so-called affiliates that feed complaints to the Federal Trade Commission, news articles, blog posts, etc. But the third bullet there is extremely significant, and that is the Better Business Bureau. Now, most consumers have not heard of the FTC complaint form on their website. If they happen to search on Google, for example, FTC complaint, it'll come up number 1, but most consumers are not aware of that form yet. They're publicizing it, and that won't be the case in the near future. But most consumers know about the Better Business Bureau. So if they have complaints about an online marketer, refunds, or whatever it is, they call or contact the Better Business Bureau, and the Better Business Bureau funnels most of these complaints straight to the Federal Trade Commission. And then if you look down in the last 3 bullets, advocacy groups. There are certain privacy groups that are looking for privacy violations. And as I said a minute ago, your privacy policy is one of the biggest sources of liability. And then at the very bottom, state attorneys general. A lot of people aren't aware of this, but we know that every state has consumer protection statutes, but 28 of them are statutes that are so closely patterned after the FTC Act, which is the federal statute that the FTC derives its authority from, that they're actually called by attorneys little FTC Acts. So really you've got 29, at least 29 entities out looking for problems that might be associated with you. The Federal Trade Commission, of course, and then 28 state attorneys general looking for the same types of things under their little FTC Acts. So now we get a little further along in the process, and prior to this phase, which is called the civil investigative demand phase, in some cases the FTC will send out an informal letter asking for information about your business, how you market. Well, if you ever get one of these, you should know that you're in serious trouble. It's not funny, but there's no, I mean, if you avoid answering, then you're in trouble. And if you, depending on how you answer, you might be admitting some things you shouldn't, so you should seek legal help immediately. But what happens after the informal letter is a very formal CID, which is essentially a subpoena, right? And the idea is for the FTC to go into a very broad fishing expedition to get a lot of information about you and your business so that they can build a case and create a complaint against you to basically shut you down. And the typical approach, of course, is for the marketer to go to an attorney. The attorney says, well, let's file a motion to quash, which is a fancy legal term for a motion to reduce the scope of the subpoena, right? But look at the top of the page. Guess who gets to hear and decide whether to grant the motion? It's the same group that filed the darn CID. That's the Federal Trade Commission. So most of these are routinely denied, and that's what this is, an order denying a petition to quash. But, you know, it just happens. This is the way it happens. Now, I'm going to mention in the next 2 or 3 steps actual cases. Briefly, we'll get into more detail on some cases in just a few minutes. But this case involves a very recent case against a company, a small, you know, here we're talking about little guys, right? Apply Knowledge, they were involved in coaching programs, marketing those, and their problem was deceptive testimonials. And here is a clip taken from the top third or so of the first page of the complaint. You see on the left side, Federal Trade Commission, and below it, Apply Knowledge, and then the other entities that were affiliated, right? And then below that, you cannot see it, are all of the individuals who are involved in these companies. Now, you may know from your general knowledge of civil litigation that if you operate in an entity such as a corporation or an LLC, that in normal civil litigation, your personal assets are protected by the corporate shell, right? And in order to pierce that and to get to your personal assets, the plaintiff has to go through a lot of extraordinary steps, has burdens of proof to satisfy in order to get to your personal assets, and it's not easy, and it's not very frequently done. But with the Federal Trade Commission, there's no such thing as a corporate shell. They name you as a defendant personally down there, and then it's done. I mean, they have jurisdiction over not only the entities involved in what they think and they claim to be deceptive marketing practices, but they have jurisdiction over the parties involved in the ads that were deceptive. They don't have to jump through any hoops or anything. They simply name you as a defendant. And then if you look on the right-hand side of this page, you see what should make the hair on the back of your neck stand up a little bit, and that is a temporary, this is an order now. This is an order from the court, United States District Court for the District of Utah, temporary restraining order, meaning a TRO, basically shutting down the business, an asset freeze, and the appointment of a temporary receiver to take over the business. So at this point, you haven't even been served yet, and you're out of business. More on this in just a second. This is another case, very similar. Again, a small guy, a little guy, online entrepreneur, Again, coaching programs involved in the sale, and again, deceptive ads. So in this case, I'm showing you a clip from the order that the court signed talking about the receiver's duties. You remember in this case and in the prior one, the receiver was appointed to take over your business. So you see in paragraph A that the receiver assumes full control of your business. And then B, takes exclusive custody and control of all your assets, documents, etc. Well, you're done at this point. You're not permitted to run your business anymore. The receiver stands in your shoes and takes over. And then this step, this is also taken a clip from that same order involving Online Entrepreneur and the individuals. This is what an asset freeze looks like. And believe me, you don't want to ever be here. You see in the highlighted language, you're hereby restrained and enjoined from assigning, concealing, converting, dispersing, etc., any asset underlying there. So that includes bank accounts, real estate, what have you, personal assets, because you're named personally here. Your bank accounts, everything is frozen. So I'm wondering how in the world you pay your mortgage, how do you pay your bills? The question is, you have a very difficult time doing it unless you've got some cash under the mattress somewhere. So this is what it looks like. Trust me, you don't want to be here. And then we move along in the sequence of what it's like, and this is an actual case involving a business named Commerce Planet and also some individuals. It was a membership site, and their problem was they failed to disclose continuity payments, which were, you know, the monthly payments that members make until they opt out of the membership. The point to be made here is that these two individuals, Aaron Gravitz and Charles Gugliusa, I believe that's pronounced correctly, made different choices. And the choice, you might remember in one of the, oh good grief, Choose Wisely, in one of the movies. I won't get into that. I want to stay on the topic. The FTC, once all of this occurs, the next step would be to make a non-negotiable settlement offer. Not negotiable. The interesting thing is, if you look at the cases which I've done, in every case, I believe, I'm not aware of any exception, the people involved who settled and took the non-negotiable offer ended up better than those who decided to fight the Federal Trade Commission. And you see Gravitz here settled for $192,000, but Charles decided to fight. By the way, he's the attorney who thought he knew better, right? But he didn't really know what he didn't know. He thought he was disclosing the terms for the continuity plan, but he really wasn't. According adequately, it wasn't conspicuous enough. According to the FTC, he decided to litigate. He got nailed for $18.2 million. And early this year, by the way, I just saw something maybe about a month ago where he has now filed bankruptcy, and his attempt is to essentially discharge himself of this $18.2 million hanging out, this judgment, right? That was, he appealed to the Circuit Court of Appeals level and lost, right? So he has that judgment hanging over his head, and his argument is he should be able to bankrupt and discharge it. But the courts routinely refuse that because an FTC, a judgment based on an FTC claim is viewed to be a fraud claim, and fraud claims are not dischargeable in bankruptcy. So Charles is still struggling not with the verdict and the judgment, but he's trying to figure out a way to get out from under it by filing bankruptcy, and that's not going to work out for him as indicated earlier in a decision. So then the last step is the final order, and this is done generally by agreement, and the agreement, the settlement agreement, has three major points. The first one is a permanent ban or an injunction barring whatever you were doing that brought the lawsuit on in the first place. The second one is big fines, huge numbers, and those fines involve personal liability not only of the person that's involved, including their family assets. There was a guy up in Canada, Jesse Willems, a few years ago, where they got his home, they got his car, they got all sorts of personal effects that were worth money, his pool table, his wife's jewelry, that sort of thing, his wife's fur coat. So they go after, family assets, personal liability. There's no corporate shell or corporate veil. And as we see in Charles's case, no bankruptcy relief. And the third element is this very, very burdensome compliance reporting, usually ranging from 10 to 20 years, where you have to report every income you make, every job you have, everything you do, particularly if you're involved in online businesses and marketing. They really want to know everything you're doing. Very burdensome. It's like filing tax returns all the time instead of just, on April 15th. So, I mean, to do it for 10 to 20 years is an incredible burden. So that's how the final order sort of shakes out here. So now we've been through what it's actually like to get sued, and we're now in the third segment. We're going to drill down a little bit into a case or two here to get a little more detail and a feel for what's going on here with the FTC. And this is a recent case against a company known as Snapchat. Last year, you may be aware of Snapchat. One of the concerns about social media, Facebook in particular, is that you might go out to a happy hour on Friday afternoon with some friends and get a little crazy, stay a little longer than you probably should, and then you take out your cell phone and you snap a few selfies of yourself, and then a little group selfie of everybody acting crazy. And then the next day when you wake up and sober up a little bit, you start wondering about whether your employer is going to see this or not and what the employer might think. And so Snapchat says, well, we're going to allow you to send snaps, which are essentially photos of your acting crazy at happy hour on Friday to your friends. But if you put a timer on that snap or photo, it'll disappear forever when the timer runs out. Well, everybody sort of liked that, a pretty good idea, and it started selling. Problem is that the claim that the messages are going to disappear forever in the privacy policy was partially true and partially untrue, and that gave rise to an FTC claim for deceptive marketing practices. The FTC, and this is very interesting, not only does the FTC look at the way you market things, and we've seen that in the prior cases, but the privacy policy, as I've also mentioned earlier, is a huge source of liability because the FTC says that the statements you make and the assurance you give in your privacy policy are essentially enforceable contractual statements. And if you don't honor those promises, then that's a deceptive practice, and they'll bring a lawsuit against you. So the rule of thumb is you should always do what you say you'll do and don't do what you say you won't do. And that's what didn't happen here. They didn't honor their privacy policies, so the FTC brought a lawsuit, no fine for some reason, but a permanent ban on what they were doing wrong, comprehensive privacy program where they really put the screws on them about how to do the privacy program exactly the way the FTC wanted to do it, and a 20-year very burdensome compliance reporting requirement. And now we get to an interesting story. At least I find it interesting, and I think you might as well. And that is the story of a very well-known internet marketer known as Frank Kern. And this goes way back in the to the Wild Wild West days, where you see at the very bottom his entities were named by the Federal Trade Commission, and then at the very bottom Frank Kern himself individually. And what happened here was that Frank purchased some ebooks individually that had resale rights, meaning he could relicense those books. And so what he did was he purchased them all separately and then bundled them together and was going to then remarket the bundle for a price less than the sum total of the individual books could have been purchased for separately, right? Not a bad business idea, not a bad strategy or tactic, right? The problem was he didn't do it as a private label or white label offer, meaning that if he had done that, then the books would have been marketed under the branding and names of the licensees below him in the chain of distribution, right? So the problem was that it was all remarketed as Frank Kern's stuff, right? So Frank Kern's name was all over it. His sales page was involved in all the downstream sales, and the FTC said that, wait a minute, I'm going backwards here. The FTC said that it looked a whole lot like an illegal pyramid scheme. I'm not sure that it was, but anyway, what happened was his attorney said, oh, I think the FTC's got it wrong here. You need to fight this. So he spent approximately $100,000. And by the way, after this call, if you Google what it's like to be sued by Frank Kern, you can read this story, which is extremely interesting, very well written, very entertaining. I'm just giving you the highlights here. So the attorney said, let's fight, and he said, okay. So then he started litigating with the Federal Trade Commission, which is a huge mistake. You just cannot afford to litigate and to do battle with the U.S. government, right? So he had spent approximately $100,000 in legal fees and had hardly moved the case to first base. He still had a long way to go to get it to trial. He realized it was ridiculous. It was a losing. I mean, just no way he could outspend the Federal Trade Commission. So then he settled for $247,000, and part of his order that he agreed to in settlement was to send a copy of the order to all of his purchasers, which were approximately 18,000, and he only got a 5-year compliance reporting requirement because back then they hadn't thought about extending it to 10 to 20, which is what they do now. So one of the things you'll see in Frank Kern's blog post that I mentioned a minute ago is not only his story about, which I've just given you the high points, but he gives you 6 lessons that he thinks he's learned that he wants to pass along to you. So I'll tick off these lessons for you. Number 1, you don't have to be a star baby to be in my show. Now that's a little vague, but what it means is if you go back to, what it means is he's the star of the show, but the people downstream of him were causing the complaints that ended up at the Federal Trade Commission, and that's how he got brought into the lawsuit. That's what that means. Number 2 is disclaimers don't matter, which is partially true and partially untrue. If you do it correctly, they do matter, but most online marketers don't. For example, the classic mistake is lose 10 pounds in your first week with our weight loss program, or make $6,000 in your first month with our money-making opportunity, right? Very specific claims, and then at the bottom of the page there's a disclaimer saying we really don't mean anything about what we've just said and that you probably won't be able to achieve those results. So a very inconsistent statement between the very specific claim at the top, the headline, and what's going on at the bottom. That's what he means by disclaimers don't matter, and the FTC doesn't like that, and they'll come after you if they see that sort of thing. Number 3, the FTC is complaint driven. We've seen that a few minutes ago. Number 4, if you're worried that what you're doing might get you into trouble, it probably will. I think that's self-explanatory. Number 5, if everyone else is doing it and they're a lot worse than you, you can still get into trouble. And this brings you back, I think, to that slide with the guy on the front row with the target on his head, and then you being on the back row. I think that's what he's talking about there. And then, for Christ's sake, get a good lawyer. Now, obviously that makes sense, but here's what happened with Frank. And this is one of the things that I think is a major takeaway from the Frank Kern's story, and that is Frank Kern's did about everything reasonable that you could expect a person to do, and he still got in trouble. And he actually, before he went forward with his marketing plan, sought legal advice from a lawyer. Now, how many people do that? Not many, but Frank did it. So he tried to do it right. The problem was that the lawyer was a tax lawyer, tax attorney, who really didn't understand FTC rules and regulations, thought they were okay, told him, yep, looks like it's fine to me. He should have gotten a lawyer who was experienced in the area of internet law, but he didn't, and that was a big mistake. But the point is, he tried to do it right, and he still got into serious trouble. And then his final lesson is the FTC is the FTC. Your best course of action is to try to be, and I like this, obnoxiously compliant with their regulations. That's sort of his final summary. So I'm going to also mention a couple of actual war stories that occurred in my law practice recently that do not involve the Federal Trade Commission. They both involve problems with the Copyright Act and a complete lack of understanding about how these rules operate. The Copyright Act is sort of like a software program that's running in the background, and if you don't understand how it runs and what are the rules that are involved in it, then you can get into some serious trouble. And this one is a case, and I'm not going to mention names because it's confidential, but my client was a woman who had created a children's book, and if you've ever seen a child's book, you know that there's not much text in it. It's mostly images. So my client had created a standard image of the basic characters, and then had created sort of like scenes that were going to be represented on pages of the book, and then employed an independent contractor artist to create these scenes and to reproduce the look and feel of these characters. So the outsourcing involved the images, right? The problem was that my client didn't understand the work made for hire rules in the in the Copyright Act, which basically say that when you outsource to a contractor, not an employee, the rules default in favor of the contractor, not you, even though you pay for the work. And what I mean is this: in order for you to own the work that you paid for and outsourced, three things have to happen. There has to be a written agreement, it has to be signed by the contractor, and it has to stipulate that the work product is a work made for hire. And if any of those fail, by default, the contractor owns the copyrights, even if you paid for them. The only thing you get is a license to use the images and the copyrights. The contractor gets ownership, which is just the opposite of what most people think. So that was the situation. We had to negotiate with no leverage because the other side had already started exercising ownership rights in the images on the internet. We had to stop that and negotiate a settlement. The legal fees that I charged to get it all worked out were over $10,000. So that was a really hard lesson for this book author. And then the next one also involved a book author where my client had written the book, the manuscript, right? And this involved a joint work where my client had written the book but then went to a collaborator, another person, who did a lot of proofing but then added some small amount of authorship. At most it was 10%, probably closer to 5%. Anyway, so my client is a 95% contributor to the final manuscript and the whole book, and the other side maybe 5%. We'll give them 10 to be gracious, right? The problem is that when you collaborate in this way, the result under the Copyright Act is known as a joint work, and the results of the joint work are that the copyright assumes that the collaborators contributed equal amounts of authorship, 50-50 rather than 90-10, right? So there's an equal share of profits, equal, even to the 10% contributor, equal rights to grant non-exclusive licenses, equal 50-50, except the other side was only a 10, maybe 5% contributor, and equal rights to create new versions or derivative works, which was absolutely contrary to what my client had intended. So again, we had another $10,000 plus fee to negotiate, because the other side was right. They had, these rights as a joint owner. We had very little leverage. We had to negotiate. We finally got it worked out. The problem is you don't know what you don't know, right? So in order to proceed safely, if you're a book author or if you're creating anything that involves copyrightable work such as course materials, ebooks, whatever it is, training materials, you really need to know these rules in order to protect yourself. Those are real war stories that actually occurred in my practice within the last 12 months. So in summary, what we've covered is the three main segments: why the FTC is now going after the little guys and why you should be worried, and then second, what it's like to get sued by the FTC every step of the way, and then third, we've drilled down into some real life examples of people who didn't think they were at risk. They didn't know what they didn't know, but they got nailed anyway, and why it could happen to you. And here's a little summary I want to make. It's really not your fault that you don't know what you don't know, and I hate to keep bringing up this don't know what you don't know cliche, but it's true. It's really been why these horror stories that we've just finished talking about have actually happened. But it's not your fault that you don't know. The problem is that ignorance is no excuse, and the consequences are extremely severe, because it's not only business assets at risk, it's personal and family. So that's a summary of the real problem. So what do you do about this? What's your best option? Well, there's no doubt that your best option is always an internet attorney who's experienced in the area, unlike the tax lawyer that worked with Frank Kern. The problem is it's sort of expensive, and most online business owners don't have the budget for it. So the next best option is FTC Guardian, our pro-level membership. We believe that this comes fairly close. Obviously, it can never replicate what an attorney does, but it comes fairly close, and it's extremely simple and easy to get involved in, and extremely cost-effective. So what do you get as a member at the pro level in FTC Guardian? First thing, of course, is a blueprint, right? It tells you every step of the way what you need to do. It makes it simple, and this is a clip of probably the top third of the first page. I think it's a 4 or 5 page blueprint that goes every step of the way, and you can see there that step one is learn what you need to know about the FTC, how they operate. Well, I think you probably could check that off already because of what we've just covered. And then you also get customized documents with RBDA technology, and these protect you right now. And what you need to understand is we're not talking about templates. Templates involve maybe a couple of options with different paragraphs and mostly fill in the blanks. By contrast, RBDA technology is database-centric. In fact, the documents don't exist. They're just a whole bunch, thousands of clauses in a massive database that I created, along with logic and questions, so that you answer a questionnaire, and in many cases, the question you're answering now was determined by your answer to a previous question. So there's a logic tree that runs underneath. You don't actually see it. You just keep answering questions. And then when you finish, the software goes to the database and pulls the clauses out that are responsive to your answers to questions, and then it assembles a paragraph, a document, one paragraph at a time. And the result here is you get a much more customized document than a template-based system, and it's what I use every day. In fact, I developed this way back in the early 90s in my law practice. I've updated it consistently, and you get to use this system, which is my system, as a member. I turn it over to you. It's not some little thing I cobble together to sell online. I turn over my private system that's very simple and easy to use. to you. And there are over 80 documents in the system. We're not talking about just a few website documents. We have 9 basic documents. Classic ones are terms of use, privacy policy. Then we have a group of supplemental documents that depend on circumstances. If you go to a marketing event and somebody takes a picture of you standing there at the social hour with your friend or someone you might be doing a JV with, and you post it on your website, you really need a model release agreement because they have rights of publicity and privacy. There's continuity plan documents because there's a federal statute about disclosures you need to make for a membership site. Those are 2 examples. 15 intellectual property documents. We have a collaboration agreement, which is exactly what my client would have needed to prevent the disaster that she had to employ me to solve for her, non-disclosure agreement. And then there are 21 customer agreements. This is something that a lot of people overlook because the customer agreement, among other things, establishes contractually your right to get paid. It also takes a lot of big steps toward limiting your liability, extremely important. And then we've got 24 channel marketing agreements where you're using intermediaries. Content reseller agreement, JV agreement are just 2 examples. So you get a whole bunch of documents that are my documents. I use them every day in my law practice. That's part of your pro-level membership. I'm not going to go through all these, but there are a lot of Kindle authors out there. It's a growing segment, and so we have a number of these documents that relate directly to them. Book author notices, collaboration agreements, copywriter agreement, graphic design, content license, coaching services, all that sort of thing that really work well for Kindle authors or any book publisher author for that matter. Also, you know that trust, know, like, and trust are very important steps to enhancing customer or prospect confidence that will lead to a customer relationship. Part of what you get as a pro member is the trust seal. You see a copy of it here. When someone clicks on it, there's a certificate that shows that you're a member. You also get really easy to understand rules and strategies. And this, you remember when we did our little finger wiggling exercise earlier on your left hand, those were the strategies and tactics that you should have been able to employ if you knew what you should know. That's what these are. They'll protect you now and in the future. And here's a listing of the various topics. And if you look here, it's what most online business owners do every day, right? Website legal compliance, of course, but most people do outsourcing, right? Most people use material of others. If for nothing other than downloading a photograph off the web, which you need to be careful doing. We all have the need for marketing agreements. We're all involved in online advertising, whether we think of ourselves as advertisers or not, with our sales pages on a post to social media. We all use testimonials for social proof. We all have privacy policies, again, a major source of liability. We all create intellectual property to a certain extent, course material, books, e-books, all sorts of stuff. So all of these things that we all do, we've got basic rules, strategies, and tactics in the form of 3 to 5 minute videos that really break down complicated stuff into really simple and easy things. But this is really the highlight here. This is what we've discovered just through doing it that has really started generating rave reviews. We had a call, I guess a couple of weeks ago. We had 350 to 400 people who are our members now on a single Google Hangout. We do 2 of these a month. My presentation is usually streamlined. I don't want to go through a full webinar mode. It's usually about a 20-minute topic on a very current new development or something that's existed in the past but that you need to really be aware of. Twice a month, usually about 20 minutes from me, and then we open it up to questions. We had a very important one. Well, I guess this was the one I'm talking about, 300 or 400 people, where the topic was the new PayPal user agreement, which, by the way, goes into effect tomorrow, July 1, right? And there were a couple of big issues there that were causing a lot of stir on the internet and blogs about the ability of PayPal to do robocalls and text messages to sell you things, and also what appeared to be an intellectual property snatch and grab, so to speak, where they were basically saying you were agreeing to a license of your intellectual property in favor of PayPal. So a lot of people were interested. We had a 20-minute a presentation by me on what these issues meant to them, and then the Q&A lasted for 45 minutes. So we always have Q&A. It's live. It's a great opportunity to ask me questions. So this has become extremely important. Where else can you go twice a month to stay on top of new developments that affect your online business? We also add material all the time. For example, we add videos of these Hangouts, replay videos, and we have other videos and other material, so that, you know, about 6 months ago we figured out it's getting a little complicated in the members area, just trying to figure out where to go to access what you need. So we added tags for keyword searches so that it's very easy to enter a keyword and figure out exactly what we've got. We also have very satisfied and happy members. I'm not going to go through these testimonials, but you can see the headlines: great compliments, really easy to use, thank you so much, exactly what we needed. But the big rave reviews we get are the Hangouts. People love them because they can suggest topics for future ones. They have an opportunity for Q&A with me. I mean, where else can you do that? Twice a month on key topics. We're getting huge rave reviews on those Hangouts to keep you current as you're going forward, because this whole business of knowing what you need to know not only involves, you know, what's happened, you know, last year, for example, and the year before, and, you know, going back to 2009 and prior to that, but you're looking at a moving target here. So you really need not only a source for figuring out what it is, the baseline that you need to know, but you need to know the new things that happen almost monthly, and that's what we cover in those Hangouts. But there's a fair warning here. You really shouldn't be tempted to try to do this by yourself, because, and one of the worst things you can do is copying somebody else's documents, particularly a privacy policy, because there's potential copyright liability, and with a privacy policy, one size doesn't fit all, because your privacy policy, you remember, from Snapchat was supposed to fit your specific marketing strategies and tactics, right? And you're not supposed to violate your promises. So if you, or you're going to be, you know, liable for a deceptive marketing practice. So if you copy the other guy's privacy policy, you're copying what this other guy is doing for marketing strategies and tactics, which may not fit you at all. And if you don't correspond to that, if you don't follow those, satisfy those promises, you're liable, right? So it's a terrible idea. And anyway, documents alone aren't going to really protect you. They will to a certain extent, but you need the strategies and tactics going forward to really protect you. So what does it cost to jump into this pro membership right now and get started protecting not only your business but your family assets? So you see a breakdown of the cost of these various, or the values of these specific elements that we've been looking at. Total value of around $3,500 in my view. I think Alan thinks it's worth a lot more than that. I've tried to be very conservative. But the retail price on our website today, right now at FTC Guardian, is $297 per year, because you have ongoing rights to all the documents and all these other elements we've talked about, some of which are ticked off here on this slide. And then, of course, the Hangouts twice a month going forward, $297 annually, compares very favorably to what you're going to be paying for an internet attorney. For example, website compliance documents generally would fall within the $2,500 to $3,000 range. If you have a membership agreement, there are very specific disclosures required. You're probably going to be looking at about another $2,000 for that. And we haven't even gotten into intellectual property or marketing documents, and we've got a bunch of those as you've seen. So, you know, throw in another $3,000, so that adds up. But what this doesn't cover, I mean, this is amazing. It doesn't cover anything, any cost associated with new developments, where, you know, for $297 a year, we do this twice a month, not once a month, but twice a month. And if you can't make the hangout, of course, it's always recorded and in the members area. So compared to the cost of an internet attorney, it's quite a bargain, but still the internet attorney gives you the most customization and the best service. So remember now that this bonus offer is there. We still have a very short ways to go, and I'm going to turn it over to Alan in just a couple of minutes to add some additional information, and he will give you the instructions on how you can get your own free copy of this book. So hang in there. You'll be able to get that very, very shortly. So to recap, very simply, for less than an hour of my billable time per month, you get all the customized documents, over 80, all the strategies and tactics you need now and for the future, and then the 2 hangouts, live Q&A with me, and the whole thing is put together with a blueprint and a very simple and easy process for you, not complicated. Final questions, though. You know, the first one is, what if you jump into this opportunity, which is a pro-level membership? What if it would save your business and family assets? Do you think it'd be worth it? Well, of course it would. That's ridiculous. That's a no-brainer. Of course it would. I just put it up there for grins, right? The real question is this: you can't really prove that because you were compliant that it actually saved you from being sued. I mean, maybe it did, probably it did, but you can't be certain. So here's the real question. What if all you can definitely point to is your peace of mind, and if you're married, this is really important, your spouses knowing that you've taken reasonable steps to protect your business and family assets? Would that be worth it? I think it would, and knowing my spouse, it definitely would be worth it. So what'll stop you from jumping into this opportunity? You might not like lawyers, and if that's the case, I'm not sure what I can do. I've heard probably all the lawyer jokes. I've been around for a while. I've heard a lot of them. Most of them are very funny, but you know, I can't do anything about it. Another thing is, you might believe that lawyers are going to harm your marketing. It shouldn't happen that way, because the role of an attorney is not to stick his or her finger in your face and say you can't do something. To the contrary, it's to define areas of risk, show you where maybe the boundary lines are, explain the options to you, and then you as a business person, you alone make the decision based on what you understand about the risk, your tolerance of risk, that sort of thing. So that shouldn't be a problem. And then the next 2 bullets, believe there's a lot to learn, and it takes a lot of time. Those are actually true, except that with the pro-level membership, we've simplified this stuff for you. We've made it very easy, and we keep you up to date with the hangouts twice a month. And then finally, you're not sure it'll make a difference. I don't know what I can do to convince you otherwise, but I can assure you that I believe clearly that it will definitely make a big difference in your business going forward. So there's really never been a better time than right now to act. And the reason is, you remember the secret we talked about at the very beginning, and we had our little hands exercise. Successful marketing strategies always include built-in legal strategies, and built-in is a key, because a lot of people are thinking, well, if I just wait until I get to a certain plateau, you know, then I'll worry about legal then. I'm really focusing on marketing now. The problem is the two go hand in hand, as we've seen, and you really don't want to wait. You need to build in these strategies and tactics as you go. And then there's another idea that I've seen on a couple of websites, which is essentially put some documents on your website and including some disclaimers, and then set it and forget it, which is ridiculous. It is an open invitation to an FTC claim. Whoever would make such a statement has absolutely no conception of what our legal system is like. I mean, it's sort of like a marketer's approach. I'm not talking about my partner Cuts, but you know, the marketer's approach, set it and forget it, and you don't have to worry about it. That's ridiculous. You need to keep up, and that's why we have the Hangouts to help you do that. But then, really, if you really boil it all down, the real reason why there's no time to delay and you need to act now is it's just too much at risk. I mean, you've seen that we're not talking about normal civil litigation. We're talking about enormous powers that they have, the FTC has, to basically shut you down and freeze your bank accounts. So I'm going to make some promises, 3 specifically. One is, as a pro-level member, you'll be happier because you'll know that you have a strategy and all the tactics to essentially take control over that gorilla we talked about at the asset. And second, you'll be more successful because you have the tools along with those strategies to actually succeed in taking control. And then finally, you'll just simply feel more of a sense of freedom because essentially you'll stop worrying about your business and the FTC, and you'll spend more time doing what you really do best, which is, of course, marketing and growing your business. Or if you're not satisfied with those 3 promises or the results, then you'll get your money back. We've got a 30-day money-back guarantee, no questions asked. That's my promise. If you don't feel like we've delivered on 1, 2, and 3 up there, you'll get your money back. So that is the final slide in my presentation, and I'm about ready to turn it over to my partner, Alan Cuts, who has some final comments. Obviously, now remember, he has how to get your copy of the free book. That's important, but and he plays this little game with me, and that is he doesn't tell me in most cases whether he has any additional bonuses, you know, that sort of thing. He sort of leaves it up. He sort of does it himself. He lets me do the presentation, and then he decides what he wants to do. So in most cases, I'm pleasantly surprised at some of the things he offers. So I'm going to turn it over to Alan and let him talk about maybe the book first, and certainly a little bit more about our final offer and whether he has any very pleasant surprises for you. Alan?
Yeah, Chip, great presentation, man. Great presentation. Do you see my screen?
Yes, I do.
Okay, I want to go over quickly with everybody so they understand that there's 84 something odd documents, and we're always adding to these as, you know, basically the documents get added to as Chip needs more documents in his law practice for people requesting stuff, right? So if somebody requests for something and more than, you know, a couple of people request for a document, it's like, I should probably add this to the pool of documents that we have, because he doesn't have to recreate them one at a time. It goes through this logic-based system. If they answer certain questions, then it pulls in certain phrases and clauses to create the document. So you get access to that. So what I'm going to start with is what you're going to get. Our normal membership is $297 a year, and I have something special for you if you hang on. That will be less than $297 a year. So we'll get down here. You get basically, you know, all your basic documents that you need for any website you own. Our enterprise membership, if you see me pointing at the enterprise membership is if you're a local marketer, hosting company, website, maybe it's a website designer or website, e-commerce website, something like that. We have a lot of companies that have taken advantage of our enterprise membership. That is what that's for. And there's a possibility for you to upgrade later. If you're a local marketer and you want to upgrade, you can upgrade to that at a discount later on. But it's not really what we're talking about tonight. It's most of the people on the call tonight are about just making sure that they're compliant online and the FTC isn't looking over their shoulders, stuff like that. So basically, you're going to get all your basic documents, legal pages, terms of use, DMAC, privacy policies, website testimonials, your website earnings agreement, all your basic website documents. In the supplement category, you're going to get, if you're a book author, you're going to get those agreements. ROSCA, you're going to get all your ROSCA agreements, forms of use. If you do, inexchangeable links and stuff like that, linking agreements and all that, as well as in the intellectual property side, you're going to get the intellectual property documents, non-disclosure documents, domain name transfer, website ownership, copyright agreements, employment agreements, intellectual property agreements with NDAs, your software acquisition, website graphic design agreements. In our customer agreement side, you're going to get your website SaaS documents, software license agreements, consulting service agreements, website development agreements, because you have to remember that if you're hiring a consultant to develop your website, that is an outsourcer. You don't technically own the code or technically own your website unless you have the proper agreements in place before they start to develop the code of that website. It's just the way it is. So we supply all those documents, web graphics, content license, software development, SaaS agreements. If you do coaching and speaking, stuff like that, speaker agreements, speaker engagement, SaaS agreements, and then our channel marketing. And this is important for those of you who have any type of affiliate marketing or affinity programs. This also includes affiliate marketing agreements, JV agreements, web specialty services, software, like OEM agreements, that kind of stuff. So you get all the SaaS agreements and stuff like that. If you do any type of SaaS or SaaS reseller agreements, that's included here. As well as, and this is what's really important. Second here. Is you're going to get based on all of the documents, you also get rules of the road and strategies for all the agreements. It's not like you just get rules of the road and strategies for FTC compliance. Right now, we're doing a whole series specifically on branding and trademark. So we talk about branding and trademark. We talk about in our Hangouts specifically about outsourcing. So in the rules of the road and strategies in our Hangouts, we talk about all the different areas, whether it's SaaS documents, outsourcing, trademark, FTC compliance. We go over all those based on what the members are looking for. So we set up and put together titles and ideas that we want to talk about, and then our members kind of control and vote out. We want to talk about more about branding. Can you help us more about trademarking and branding and what that's going to do for our business, and how can we trademark stuff more effectively, or whatever that is. And we also talk about advertising, what's called network advertising and advertising online, and what you need to be doing to make sure that your advertising is compliant and you're compliant with Facebook, Google, Bing, and all the other advertising networks. So we have all of that. So it's all a part of the service, everything we do. Plus, and this is a big plus, is I'm a marketer. Chip's the attorney, Chip's the legal guy. He knows this stuff. Well, I'm the marketing guy, so I do all the tracking, and I measure absolutely everything. And I'm sure it's been said 100 times that you cannot, if not a gazillion times, is you can't improve anything you can't track and measure. So what I've done is I've searched out for companies that to help me handle and manage one of the best tracking and management programs for managing tracking. And I've been using this program for a lot of years. So I approached them. His name is Patrick Kelly. The individual who owns the website is Patrick Kelly, who owns it, and asked him if he would, kind of help us out and provide our members with something. We know that you guys are online marketing your business. You wouldn't be on this call unless you're truly marketing your businesses on and offline. And if you're online, you need things to market your business as well as tracking your business. So what I've done is there's this product called Click Magic, and I've used it for years. I love it. I love it. Love it. And when you get a copy of FTC Guardian, we have been able to get them to throw in a full 1 year license to Click Magic. I mean, you'll be able to do probably more than most people on this call will ever do or ever use. But a lot of these features I use because I do all the marketing for this company, for FTC Guardian as well as other companies that I'm involved in. So multi-mode link rotators, advanced, and for me, advanced geo-targeting. So I can target specific using their rotator. Their links. I can technically target people in different geo areas, right? So it's great. If not this area, then send them to this area. If they're not in this link in this area, send them to something else. It's great stuff. Countdown timers, link cloaking, magic pop-ups, effortless optimizing, content locking, and this is really cool. If you have membership sites, you can lock content. A/B split testing. All magic pop-up bars, a little bar at the top of the window where you can have a magic pop-up bar that pops to the top. It's just great stuff. So if you decide to get involved, jump on board with FTC Guardian. So what you're going to get is inside FTC Guardian, there's going to be a link, and you're going to come to a window that looks like this. You're going to click on it, and it's going to come like this, and it says 1 year of free starter account. And I think it's like 10,000 plus clicks a month. 10,000 plus clicks a month. Very few people on this webinar are going to 10,000 plus clicks a month. I'm probably one of the few that might. Very few people are going to do 10,000 plus clicks of paid advertising per month. But again, it's $147 value. So here's what we put together for you. And really didn't discuss this a lot with Chip, but here's what we're going to do is you need something to compare our prices to. So here's what we're going to do is our strategy videos at a minimum are worth $997. Our Hangouts at $2 per month, I conservatively value those at $2,400. And here's why. And Chip can jump in when he wants. Chip's time is valued at $300 to $350 an hour. That's what he bills his clients, right? So you get basically 2 20-minute Hangouts a month, Chip's time per month, basically answering questions that our members post, where we go into that, and you have the opportunity to ask questions during those webinars. So it's easily worth $2,400 a month to have an attorney like Chip on the calls. Plus you get compliance documents, IP documents, marketing and promotion documents, and as well as the Click Magic bonus. Chip, do you want to jump in here and talk about just the time side of it?
Yeah, I think you're probably right. I'm not going to argue with you about the. I'm focusing on the Hangouts, because again, my presentation's always around 20 minutes, but in many cases we go Q&A. Some people decide after 20 minutes that they've sort of, they understand what we're talking about, and they have other things to do in the evening, so they drop off and feel like maybe they can check out the video later. But we have a lot of people that hang on and keep asking questions. And so I'm hanging out there with them and answering those questions. So the Q&A part goes on for 30, 45 minutes in some cases. So when you do that twice a month over, a period of time, this is an indefinite period of time, then, it could be worth significantly more than $2,400 over time.
Yeah.
So yeah, I don't quibble with that at all. I think the rest of the values are probably spot on.
Yeah, and that's why I put, total real world conservative value is, roughly $5,000. You're talking about, having access to and being able to post questions and submit Hangout topics to one of the top internet attorneys in the nation. It just doesn't get any better than that. So, so what we've done is for SuccessNet and for Michael's group is here's what we're going to do. If you take advantage of this and jump in right away, it's going to be a $297 one-time payment. Now, this will not last long. Look at the value. You can't hire Chip for $300 an hour. You can't do it. And he's an internet specific attorney who understands what is going on. So if you jump in, it's one payment of $297, and all you need to do is go to ftcguardian.com/SuccessNet to take advantage of this right now. This is pretty much it. When you
So I've got a question. How long is this going to stay open?
We're going to do this till
you'll tell me later.
Yeah, I'll tell you in a moment, but it's only for it's only for a few days. Honestly, you can't do this forever. On our website it's $297 a year. On our website it's $297 a year for the and we've got people paying that, day in and day out. So you can't do it. You do it for special offers, and you do it for, friends. I've known Michael for I think over 10 years. I think I've known Michael for over 10 years. So you do it for friends. So when you go to that URL, you're going to see this. You're going to want to click on the but, enter your email address, click I agree. And when you do that, you're going to come to a page that's going to say $297 one-time payment. This is a special offer we're going to set up as a one-time payment, and enter your name, credit card, all that kind of stuff. Submit your order. And then this is the page that I want to make sure, as a kind of a special bonus, we have a private Facebook group. So what you want to do here is, after you purchase, is enter your information here and make sure you give us your Facebook email address, because not everybody uses the same email address when they're purchasing something versus what they're using on email on Facebook. So, but we need your Facebook email address so that we can invite you into our private Facebook mastermind group. So you want to make sure that you do that. And then after you log in, you're going to get your information, you're going to log in, you're going to end up on my account page. It's not this page, it's another one that says my accounts. Once you do my accounts page, you're going to update all your information, click the submit button because it needs to be updated. And then you'll come to this and you get your 1 year. You want to click on this link here and you'll be able to enter your order ID. You want to make sure you enter your order ID for Click Magic, and we do that. So basically, it's all laid out. You get the strategies videos, you get the Hangouts, $2,400, compliance, IP docs, at minimum $597, marketing promotional documents at a minimum of $597, plus Click Magic. If you do any kind of marketing, if you work online, you cannot be marketing online or doing anything online if you're not tracking. if you're not tracking what the hell you're doing. So you get all that. So roughly it's $5,000 value for a one-time payment of $297. So all you need to do is go to ftcguardian.com / SuccessNet, and that is really it. Chip, do you have any last words, anything you want to say before we log out and give everybody the...
Yeah, the only question I have is, again, how long does it stay open? It's a great offer, that single payment of $297. So my questions are two, and I'll turn it back on. One, how long does this offer, very limited, stay open? I know it's limited, just when does it end? And then second, how do they get the book?
It's funny you say that because people are asking that. People are asking, how do they get the book? So here's what we're going to do is the pro payment, just so you know, is, I'm sure you know by now, it's $297, one-time lifetime access. And it's, what's today? Tuesday. So we'll leave it today. Today's Tuesday, right?
Correct. Tuesday.
July 4th weekend. So we'll leave it until Sunday because that's July 4th is Saturday. So we'll leave it until Sunday. So you'll have till Sunday. So that's
Sunday to midnight.
Sunday. Let's go Sunday midnight. Let's go Sunday midnight.
Okay.
FTC Guardian / SuccessNet. So here's what we want to do is we have a Facebook page. Is go to facebook.com / FTC Guardian. And just give us a quick thumbs up, give us a quick like on the page, and then, post a quick comment. What do you thought about and it's really what we want is what did you think about the webinar and what we're doing? And if you've already purchased, tell us why. Tell us why you invested in FTC Guardian. Why did you jump on board? Why did you decide to do it? Because, whether you know it or not, we are the only, as far as Chip and I, either one know, we are the only company out there training people specifically on FTC compliance. I mean, there are a gazillion, 55 plus million companies online, and nobody's training them. Nobody's teaching them about compliance and what they really need to be do. And 90% of the businesses online today, small business specifically, are out of compliance. It's just the way it is. And they are like, big flag waving to the FTC, look at me, I'm out of compliance, waiting for a lawsuit. It's kind of like, not having health insurance and getting stricken with that big disease, or having a broken leg, because you didn't have basic health insurance. It's just like that. So go to facebook.com FTC Guardian / FTC Guardian. Give us a like and give us a comment on what you thought about the webinar. Now, to get a copy of the book, email book@ftcguardian.com. In the subject line, just put I did it. Email book@ftcguardian.com / and the subject line, put I did it. That's all there is to it. And go to ftcguardian.com / SuccessNet and grab your copy of FTC Guardian. And we'll look forward to having you in the membership area and having you on the next members only hangout, which I believe is scheduled for July 9th. I believe the next members only hangout is July 9th. I believe it's the 9th and 23rd are the next two in July. And topics, I know we have an idea for one topic already, and we'll have the topics shortly for both of them, and you'll let know. So Chip, you have anything else?
Well, that's all I've got. I really like what you put together for everybody. I think it's extremely compelling, just a single payment, and then the click magic, and of course the book. So I think it's a great offer, and I really do want to thank Michael for hosting us tonight, and I look forward someday to meeting Michael in person. We had a great chat just before the call tonight, and really enjoyed chatting with him, but I look forward to meeting him in person. So that's all from me. Thank you very much for attending, and We hope to see you in our Hangout calls in the very near future as a member.
All right. Thank you, everybody. Goodbye.